For the sake of expediency, I will not rehash the evidence of all the experts in detail, since they all came to one conclusion. Suffice to say that Dr. Ntsele, with reference to his report, which is marked Exhibit Y of the record, evaluated the post-mortem report compiled by Dr. Van Zyl in 1967 and noted the following. 1, that the injuries indicated on the said post-mortem report do not resonate with the injuries that would have been expected from a pedestrian involved in a train accident. 2, that generally, a person who was struck by a train would sustain multiple fractures on different regions of the body. 3, that generally, a person struck by a train would sustain multiple abrasions, bruises, and/or lacerations. 4, that the injuries recorded on the face of the post-mortem report are grouped without providing specific distinctive details about the injuries in relation to wound measurements and specific locations within the anatomical sites. 5, that it is not revealed how many and how big the scalp lacerations and bruises were. 6, that there was insufficient description relating to the extent and severity of the fractures sustained by Chief Luthuli. 7, that there was no diagrammatic description of the location of the injuries on the body of Chief Luthuli. 8, that there was no documentation of the clothing of the deceased, and therefore it was not possible to obtain cues, the presence of the debris, like grass and or soil or sand, which would give an idea as to where the person could have been and where he was injured. Number 9, the postmortem examination was so hurried that it was conducted 90 minutes after the death and whilst the body was still warm. There was no cultural or religious reasons necessitating the examination to be done so soon after the death, even before rigor mortis had completed. Number 10, with reference to Dr. Gregerson's evidence in the 1967 inquest, Dr. Ntsele observed that the X-ray records were omitted. This was done deliberately to conceal vital evidence of the actual injuries. Also, with reference to Dr. Gregerson's evidence in the 1967 inquest, Dr. Ntsele observed that Dr. Gregerson omitted to state whether the fracture on the left elbow was simple or a complicated one. Had this been detailed, then it would have been possible to ascertain the amount of blunt force which could have contributed to this fracture. Further, that given the distribution and nature of the injuries, one would have expected the clothing to be full of blood. However, Dr. Gregerson had noted that there were no signs of dragging on the body, but that the clothes were torn and dirty. And lastly, in as far as Dr. Gregerson is concerned, Dr. Ntsele noted that there was no physical evidence to suggest that Chief Luthuli was thrown some distance away on impact. Yet Dr. Gregerson conformed to the conclusion reached by the evidence leader in the 1967 inquest that Chief Luthuli was thrown away some distance on impact. And as far as Dr. Jubert is concerned, Dr. Nsele made the following observations: that Dr. Jubert's conclusion that Chief Luthuli died as a result of head injuries as well as chest injuries does not make sense. This for the reason that Dr. Jubert, on the other hand, concluded that, and I quote, it was not possible to determine whether there was an associated hemothorax. Further, that the quality of the medical attention given to Chief Luthuli is riddled with a number of omissions. These omissions include, for instance, the failure to immediately transfer Chief Luthuli to King Edward Hospital in Durban, but instead to retain him for close to 2 hours at Stenger Hospital, which was not properly equipped to treat patients with head injuries who needed neurosurgery intervention. After a careful analysis of the injuries sustained by Chief Luthuli, including the final condition of his body and clothing, Dr. Nsele was of the opinion that Chief Luthuli was assaulted and died as a result thereof on the same date, being 21 July 1967. His conclusion is as follows, and I quote, "The presence of bruises on the dorsal aspect of both the left and the right hands, as well as the fracture on the left proximal ulnar bone, may signal defense injuries, which would normally occur when a victim of assault instinctively raises his hands and arms to protect his eyes, face, or head." Close quotes. Now, I have as Annexure A a detailed analysis of the evidence presented by the experts in the name of Warrant Officer Sunil, Warrant Officer Burgess, Mr. Labus Kahni, and Mr. Van Tonder. The analysis of technical evidence presented at the initial inquest held on the 19th of September 1967 compared to the current reopened inquest, which commenced on the 14th April 2025. It is pertinent to provide the analysis of technical evidence presented at the initial inquest and find comparison. Through this analysis, this court was persuaded to overturn the 1967 inquest with respect to the death of Chief Luthuli. The overturning of that rule would amount to a just verdict with respect to the circumstances which led to the death of Chief Luthuli. The evidence that was presented before this court sets out the details as provided by trained experts, the reconstruction and simulation experts, as well as the medical experts in the name of Dr. Nsele, which I've just gone through. In the simulation evidence, it was demonstrated that the locomotive, similar to the one that supposedly knocked down Chief Luthuli, would be improbable. In fact, it wasn't there. There wasn't any accident, according to the simulation expert. It was demonstrated here in court and video, and we watched how Labuskachne demonstrated the train, which is exactly the same, save for the train number, to that of the 1967 locomotive. There were also inconsistencies and improbabilities in how the guard, after the train had stopped, had to go and protect the train. It was also not clear from the evidence of 1967 how a train master could allow the train to proceed with its journey to Durban instead of cordoning off the area and regard it as an accident scene and have police officers immediately investigate forensically what could have happened. The drawings that were provided by Detective Sergeant Lewis in the 1967 inquest were also criticized in the sense that they make no sense. It is only through the reconstruction experts that one would get a picture which ultimately shows that there wasn't any investigation. There wouldn't have been any investigation since the train had already left for Durban. So it would have been difficult to see exactly whether the train stopped at a particular point, as Lategan said. For the sake of interest, the detail of the expert evidence was, the analysis of the different evidence presented by Lewis and Berger compared to the evidence presented by witnesses in this reopened inquest was ably compiled by Advocate Chwene and comprises several pages. It will be attached to this judgment as Annexure A. The other vital links of eyewitnesses is as follows. As a result of the reopened inquest being widely publicized through the media platforms, witnesses started coming forward. One, Mr. Bafin Mdletshe, aged 70 years, came forward to testify as follows. He became aware of what actually befell Chief Luthuli on the fateful day of the 21st of July 1967 through what the late Potwayo Barnabas Mnyandu, who died 5 years ago, around 2019 or 2020, related to him. Mdletshe's affidavit was subsequently taken down in writing by the investigating officer, Lieutenant Colonel Stein, and has been accepted into the record as Exhibit AA. The late Potwayo Mnyandu was the son of the late Thomas Mnyandu, an Induna in Genezano area in Lamesi, KZN. At that time, the black people were involved in an ongoing land claim dispute, which is still going on to this day. Ndletshe was in due course earmarked to take over as chairperson of the Land Claims Committee. It was during the process of the takeover during 2015 that the elderly Potwayo Mnyandu shared with him the vital information. This information had been related to him by Thomas Mnyandu, as I've said, about the eyewitness who observed Chief Luthuli being assaulted by white men from the train that was stationary at the Umvoti River Bridge on the 21st of July 1967. This eyewitness was the younger brother of the late Potwayo Mnyandu. It later turned out during this reopened inquest that the name of this younger Mnyandu was Mbemu Mnyandu, as per information obtained by the investigating officer, Lieutenant Colonel Stein, from an elderly lady, Mrs. Ncwele, who is now aged 84 years, on 25 June 2025. The said Mbemu Mnyandu had possibly witnessed the incident of assault of Chief Luthuli when he had been sent to deliver a letter to him at his home in Groudville, only to be directed to the cane fields where Chief Luthuli was supposed to have gone. Mbemu rode his bicycle and purported to go to the cane fields to deliver the letter. Fortuitously, he saw Chief Luthuli being assaulted with a shovel by the train occupants, the train workers that had been from the goods train. When the assailants realized that they were being watched, one of them gave chase to Mbemu, who fled the scene in his bicycle. One can conclude that the assailants were disturbed and could not complete their assault on Chief Luthuli. To this day, we can only draw inferences that Chief Luthuli would have died at that particular point, with all the evidence being hidden forever. It is clear when one considers the simulation experts' evidence as to how a person who is knocked by a train would have all the parts of his body dismembered to the point of not being recognizable. We can only have various scenarios. Perhaps the notion that Lategan tried to make Chief Luthuli lie in a more comfortable position actually would mean that they tried to drag him onto the rail lines had Mbemu not caught them in the act. A few days after the 21st of July, 1967, police officers from either Tongat or Verulam police station came to the Mnyandu homestead to look for Mbemu Mnyandu, and eventually they got him. They took him away under the pretext that they were going to take a witness statement from him. To this day, the said Mbemu Mnyandu has never returned home. Luckily for the Luthuli family, for the African National Congress, for the comrades, for the international world. This gives a glimpse of what actually happened to Chief Luthuli. Even if Mbemo, unfortunately, is never found, and in all probabilities is presumed dead, but the truth always has a way of coming out. Mr. Sibongile Elizabeth Ndimande born Mnyandu also echoed the sentiments expressed by Mdletshe about the activities of her grandfather Thomas Mnyandu, as well as the disappearance of Mbemo Mnyandu. This event about Mbemo's disappearance became one of those topics that are never spoken about in the family gatherings for fear of negative repercussions. The impact of Chief Luthuli's death still looms large amongst his family as well as amongst the public in general. Mrs. Lindiwe Nana Ngobese Mmalu read into the record the victim impact report, which was accepted as Exhibit CC, which had been crafted by her for the living grandchildren of Chief Luthuli. The report detailed the impact that Chief Luthuli's death had on his family. It is evident from the reading of the said report that the entire family still feels a lot of pain. Had proper prosecution been done in 1967, the family would have been vindicated in seeing those responsible for Chief Luthuli's death being brought before appropriate criminal courts. Chief Luthuli had a number of grandchildren, and I shall deal mainly with those referred to in the report submitted by Mrs. Lindiwe Nana Ngobese Mmalu. Firstly, the Ngakane children, born of Dr. Albert Luthuli and Dr. Pascal Ngakane, feel that they were forced to live in exile as a result of the actions of the killers of Chief Luthuli and the institutions associated with those killers. Secondly, the Kabasha grandchildren have suffered far-reaching effects and fear. Thirdly, the Ngobese grandchildren, their mother is the author of the aforesaid report, Exhibit CC, painfully reflected on their grandfather and how he suffered to his death. They equate any attempt to erase Luthuli's death to actually erasing it from the history of Africans at large. I must add that today we have several government buildings, roads, and other institutions named after Chief Luthuli in almost every big city, to demonstrate how difficult it is to erase the legacy of Chief Luthuli. Christian and Cynthia also separately echoed the sentiments of loss. Fifthly, the children of Wilhelmina and Edgar Luthuli were also seriously affected. We saw and heard Mthunzi Albert Luthuli testifying before this reopened inquest. His demeanor demonstrated that he still feels heavy pain as a result of the loss. My final evaluation is as follows, over and above what has been said above. In assessing the evidence presented to this court in the reopened inquest, I bear in mind that the standard of proof is not as stringent as in the criminal case, in respect of which the test is proof beyond any reasonable doubt, nor is it the standard of proof on a balance of probabilities, as is the case in civil trials. In the decision in Ray, Goniwe and others, 1994, Volume 2, SACR 425 bracket SE at 427B, Zitman JP, dealing with the standard of proof required for a positive finding to be made in terms of Section 16, subsection 2, subsection D of the Act, said the following, and I quote, "An inquest is held where it appears that the death has occurred, that such death was not due to natural causes, and where criminal proceedings have not been instituted in connection with the death. In the case of DRNO versus Tilly, 1990, Volume 2, SA 899, bracket A, Smallberger JN, stated at 901 E2G as follows, quote, "The function of an inquest is to determine the identity of the deceased person, the cause of death, the date of death, and whether the death was brought about by any act or omission involving or amounting to an offense on the part of any person, whether the sorry, let me read it again. The function of an inquest is to determine the identity of the deceased person, the cause of death, the date of death, and whether the death was brought about by any act or omission involving or amounting to an offense on the part of any person." In terms of Section 16. Subsection 2, this determination would include, insofar as possible, a finding as to who the responsible offender or offenders are. The underlying purpose of an inquest is to promote public confidence and satisfaction, to ensure that the public that all deaths from unnatural causes will receive proper attention and investigation, so that, when necessary, appropriate measures can be taken to prevent similar occurrences, and so that the person responsible for such events may, as far as possible, be brought to justice. Close quote. I've already referred to the decision in Timor and another, as well as to the DRNO versus Magistrate, Cape Town, where Van der Heever J. stated that, in open quotes, "An inquest is not aimed at proving anyone's guilt, but is most certainly aimed at ensuring that, if possible, where guilt exists, it will not remain hidden." Close quotes. The above quoted decisions, amongst many others, mean that even where those who are found to be responsible for the death of a person are known, and their identity in some form should never remain hidden forever. In this matter before us, all the culprits have since died, as Lieutenant Colonel Stein has testified and submitted affidavits to that effect. Lategan could not be found. Grayling has died. Dr. Gregerson has died. Dr. Van Zyl has died. They all have died. And unfortunately, their death was years after 1967. They could have been found, we could be seeing them today. But, well, they have died. An in-depth analysis of the technical evidence presented at the 1967 inquest and of the analysis of the reopened 2025 inquest has been done through the evidence of trained experts, as I've said, the simulation experts as well as medical experts. It shows one thing, this in-depth analysis, that the 1967 inquest is riddled with lies and inconsistencies. The persons of authority, from the presiding magistrate Boswell to the medical personnel and the police officers in the person of Detective Sergeant Berger and Lewis, and the South African Railways laborers, including the train driver, the fireman, the conductor, and Mataba, were all hell-bent to cover up the circumstances leading to the death of Chief Luthuli and to present false evidence that Chief Luthuli was struck by a goods train. Dr. Nsele, as I have highlighted above, in his evidence before this reopened inquest, testified about the discrepancies in the evidence of the 3 medical practitioners involved in the 1967 inquest. The police officials, Berger and Lewis, have also been shown to have not done proper preservation of the scene of the so-called train accident. This shows that there was no train accident. Also concerning is that Gladhoe Station Master, Mr. Pretorius, would allow Lategan, Grayling, and Van Wyk to proceed with their journey in the goods train to Durban, despite the so-called train accident. This was done even before the injured Chief Luthuli was removed by ambulance to hospital. The railway laborer, Ntsakani Mataba, who said he was working on a new bridge that was constructed nearby, told the 1967 inquest that the whistle of the train was not blown, and he later considered that it could have been blown, but he was prevented by the strong wind blowing from the southwesterly direction. There was no blowing of the whistle. Regard being had to the contradictory evidence of the train driver, Lategan, Grayling, the fireman, and Van Wyk, the conductor. There are also timeline discrepancies between the evidence of all the rail employees involved. If one compares that to the evidence of the ambulance driver, Papaya, they mention different times to the extent that one would think that they are talking about different events of a different date. The 1967 inquest proceedings were flawed. The court in 1967 failed to thoroughly evaluate the evidence presented by the persons at the scene and to compare it with the conflicting evidence of the witnesses who were not present at the scene, like Mrs. Mfega, Mrs. Zipi Gumede, and the so-called grandchild of Chief Luthuli, Eric Chili, who turned out not to be known to the family. At the end of the day, reading of the 1967 inquest records reveals that Chief Luthuli was not provided with the much needed emergency medical care. Instead, a neurosurgeon was called from Durban to travel to Stenger. Stenger being a hospital which I must say, it is public knowledge that it's not fully equipped for most of the medical needs of the people around Stenger. The evidence of expert witnesses who testified in this reopened inquest shows that all these experts are competent experts, and they are competent to express their particular opinion. They all have personal knowledge of the topics they testified on and have experience on their respective topics. They relied on the knowledge and experience of other acceptable experts in their respective fields. They demonstrated that they have grounds upon which they base their opinions. In short, they met all the requirements as expounded in the case of Monday versus Protea Insurance, 1976, Volume 1, Essay 565-EC. It is true from the evidence adduced in this reopened inquest that as Advocate Msimang submitted, there was, and perhaps even currently, an entrenched culture of lying about the true facts where the murder of a political activist is involved, and that apartheid was institutionalized, with law being the primary tool used to give effect to apartheid. We consider here actions of the medical practitioners that I have mentioned, who were stationed at Stenger Hospital, and those of Dr. Ubed, a neurosurgeon stationed at Wentworth and King Edward Hospitals. In isiZulu, I would say, and these are my own words, wafika eStenger Hospital wazomqedela, close quotes. We consider also that even magistrates in the law courts use the law to push clandestine agenda. Consider the actions of Mr. Boswell. Mr. Msimang, Advocate Msimang further referred to the cases of Griffiths Mqengi, Mr. Hafaji, Mr. Timol, Mr. Imam Harun, to name but a few. Mr. Msimang further submitted that in this case we are dealing with here, there was careful planning that involved even demolishing the Mvoti River Bridge and constructing a similar bridge over Nchaweni River. The aim would only to get rid of the evidence even for yet later years, because as we sit here today, we cannot do an inspection in loco on the Mvoti River Bridge because it's no more there, it's lying in ruins. Advocate Ngobo gave us an international law perspective, rehashing that it was in 1966, a year of specific resolution of the United Nations General Assembly, that Chief Luthuli was visited by Senator Robert Kennedy. Gravely concerned at the intensification of the policies of apartheid in South Africa, the General Assembly noted with concern and expressly condemned what was happening in South Africa. They were saying that apartheid was a crime against humanity. Chief Luthuli was subjected to such crime against humanity. Mr. Ngobo echoed the sentiments expressed by Advocate Dunya, the leading prosecutor, who referred me to the most recent decision in the state versus Mfalapisa Ephraim and two others. It's an unreported decision, case number, it's a 2025 decision of the Gauteng Division of the High Court, dated 14 April 2025. When he said, those responsible for murder, alternatively culpable homicide, and crime against humanity in contravention of the relevant customary international law and Section 233 of the Constitution should be held liable by direct conduct or vicariously liable as authorities in charge of those who executed these crimes. Advocate Ngobo further referred me to the article by Professor John Dugan in alluding to the fact that apartheid was officially criminalized in 1973 as a crime against humanity, and that inhuman acts resulting from the policies and practices of apartheid and similar policies and practices of racial segregation and discrimination are international crimes. The Apartheid Convention refers directly to the South African circumstances. The persecutors of Chief Albert Luthuli, as well as other persons opposed to apartheid, therefore amount to crime against humanity, and so does this murder of Chief Albert Luthuli. Advocate Dunya, in closing, submitted that the evidence presented is sufficient for this court to set aside the findings of the 1967 inquest and to substitute same with the finding which I shall make in due course. From the body of the evidence adduced before me, this court can be accepted that there exists evidence which was not presented before the 1967 inquest, which necessitates that this court makes a fresh finding in terms of section 17, capital letter A, subsection 3, read with section 16, subsection 2 of the Act. That there was no thorough investigation into the circumstances around the death of Chief Luthuli. And that court in 1967 was not presented with sufficient evidence to make a credible prima facie finding in terms of section 16, subsection 2 of the Act. Having considered all the evidence, including expert evidence, which was very valuable to this court, and I must say that the evidence presented by experts before this court corroborates what Mpemu Nyando saw. He's not here to testify, but what he relayed to the Nyando family is corroborated by all the experts that testified before this court. I therefore give the following order. 1, point A, the finding and the ruling of the magistrate, Mr. C.I. Boswell, dated 19 September 1967, at the Stenger Magistrates Court under Inquest number 76 of 1967 is set aside. B, in terms of section 17, capital letter A, subsection 3, read with section 16, subsection 2 of the Inquest Act 58 of 1959 as amended, the following orders are made. Roman figure 1, in terms of section 16, subsection 2A, the deceased is Chief Albert John Mvumbi Luthuli, an African male and the president of the African National Congress. Roman figure 2, in terms of section 16, subsection 2B, as to the cause or likely cause of death, it is found that the deceased died as a result of a fractured skull, cerebral hemorrhage, and concussion of the brain associated with an assault. Roman figure 3, in terms of section 16, subsection 2C, as to the date of death, it is found that the date and time of death is approximately 14:25 p.m. on Friday, the 21st July 1967. Order number 2, in terms of section 16, subsection 2D, as to whether the death was brought about by any act or omission prima facie involving or amounting to an offense on the part of any person, it is found as follows. 2.1, that the death is attributable to cumulative acts and omissions of the following. 1, assault by members of the security special branch of the South African Police, acting in concert and in common purpose with employees of the South African Railway Company. 2, that the following persons committed the crimes or offenses of defeating the ends of justice, perjury, and being accessories after the fact to the crime of murder. These persons are as follows. Mr. Albertus Stephanus Lategan, the locomotive driver, whose whereabouts cannot be ascertained. B, Mr. Daniel Lessing Grayling, the fireman, whose whereabouts cannot be ascertained. C, Mr. Peter Francois van Wyk, the train guard, whose whereabouts cannot be ascertained. D, Detective Sergeant Andres Petrus Berger, Railway Police Officer from Stenger, whose whereabouts cannot be ascertained. E, Detective Sergeant Charles Barrand Petrus Lewis, Railway Police Station from Devon, whose whereabouts cannot be ascertained. Andres L.H. Pretorius, Glado Station Master, whose whereabouts cannot be ascertained. Mr. Stein of the Glado Station Foreman, whose whereabouts cannot be ascertained. And the members of the South African Police who are alleged to have pursued and eventually kidnapped Mbemu, Nyandu in connection with having witnessed the assault on Chief Albert Luthuli. Order number 3, it is ordered that a recommendation is hereby made that the Director of Public Prosecutions fully investigate the circumstances of the kidnapping or forced disappearance of Mpemo Nyandu following his witnessing of the assault on Chief Albert John Mvumbo Luthuli. And lastly, that it be recognized that the institutionalization of apartheid, which was already a crime in 1948 according to the international common law, and with respect to which the case of Chief Albert John Mvumbi Luthuli was handled, is evident from the acts and omissions of members of the following government departments. A, Department of Health. B, the South African Police. C, South African Railways Department. And D, the Department of Justice. I must at this point, at the end of this grueling inquest, thank everybody involved here. Lieutenant Colonel Stein, thank you very much. Warrant Officer Sunel, thank you for being our Chief Luthuli for the time being in this simulation. And I must thank all the investigators, Warrant Officer Pages, for the reconstruction. That was very enlightening. I see Mr. Latekhan and Mr. Van der Tonder are not here, but I thank them in absentia for providing us with their train and for the valuable information. And most of all, thank you, Mr. Dunyo, for leading your team so well. Ms. Chwene, thank you for producing sterling work. Mr. Ngobo, thank you very much. I don't know why Mr. Ngobo sits so distant away from them. Mr. Msiman, thank you very much for the work that you've done. And the museum, the team from the museum, Mr. Tusi, Mr. Baba. And thank you everybody that has had the patience to come and sit and listen to us. Thank you, Mr. Jeffrey Khatebe. Thank you, Nkosazana Zuma. Thank you. I can't mention everybody. Thank you, is May here, Veli. Thank you very much. And thank you for Dr. Luthuli. I don't know whether she managed to make it. And also all the children and grandchildren of Chief Albert Luthuli. My secretary says, oh, okay, there are so many people to thank here. Let me take my glasses off. I see Mr. Spoon Debele. Thank you very much. I think that finalizes my job. I will make sure that the copy of the judgment and the Annexure A, which has the details of the time analysis, the distances of the train, measurement of the tonnage of the train, all the simulations that were done, we've got them on record, but I will get Mr. Dunya in due course to provide that to the museum so that whoever wants to read more on this may do so. And I will request Mr. Jeffrey Khadebe to provide those 2 books that he used in his testimony so that they also form a part of this record to be delivered to the prosecuting team for onward transmission to the Luthuli Museum. Thank you, court agents.
Thank you. Yeah. The whole team, guys.